balance sheet, profit and loss statements, cash flow, and tax returns from August of 2021 forward. That is request for production number 6, and we actually have that screenshotted in our brief. Defendants have objected on that it's overly broad, not reasonably limited in time, and that it's not relevant. And Your Honor, they have previously produced these categories of documents for other time periods, so it's not a burden issue. In terms of time, August 2021 forward, that's not an overly broad amount of time. And finally, as to relevance, Your Honor, what we've put in our reply that we filed this morning to make it clear, we've pled several different causes of action that make this relevant. We are, the Tim Seib Trust is a current owner, so under the Texas Business Organizations Code, these are books and records he should have access to. He has the trust has a claim for a breach of fiduciary duty, both in its own capacity and as a derivative claim, and is entitled to investigate misuses of funds. And one example we have for Your Honor is that at a prior hearing, defendants had said that they had separately kept these distributions to the Tim Seib Trust. We found out there was no such account. They had a bank account that they're saying they're keeping the purchase price that they're not going to give to the Tim Seib Trust during the pendency of this case, but defendants can access it whenever they want to. Those are not the same thing. So at the end of the day, we want to be able to have the underlying financial documents to see what is going on. That's the first category. Your Honor, I'm happy to stop there if you have questions or just give you the full summary.
Yeah, the response.
Yes, Your Honor. Well, a couple of things here as to that one. First off, counsel's correct. I mean, our objection is actually a little more notable than that. It relates to also, I mean, obviously relevancy in the court knows the request also has to be reasonably calculated to lead to admissible evidence. As Your Honor will probably remember in this case, there was an evaluation in this case of Mr. Seib's interest. That's February 28th of 2021. That valuation is put together by a third-party independent appraiser, was agreed to by both parties. Okay, so that's where, and so that evaluation is put together. It's put together in accordance with the company agreement. My clients have followed every step as it relates to getting this membership interest bought out all the way through 2021. We provided documents through August of 2021, all the financial documents that they're asking for now. So this is only after the fact, after not only did we choose an appraiser to do the valuation as it relates to Mr. Seib's interest, who was being bought out, we used who they suggested essentially to do that valuation. And now it's after the fact, and they want to come back and say, you know, oh no, we need to look at all the documents from August 2021 forward. It's incredibly irrelevant to this case, frankly, Your Honor. It's not going to lead to admissible evidence in this case because, and another part of the objection is the prejudicial effect that that's going to have. I mean, financial documents of this company, which he is no longer a member of, from August 2021 going forward is only going to muddy the waters. And they know that. That's why they're asking for these documents right now. The operative date that was agreed to by all parties was February 28, 2021, per the company agreement, which they followed along with and they were fine with up until way after the valuation was already done by a third-party appraiser. And now they want to come back and say, oh no, we need additional documents going forward. When the court, I understand that there's a summary judgment still pending before the court on the issue, but I mean, until the issue of the contractual obligations, whether they were followed, is determined, there's potential prejudice that may, that may follow essentially by allowing this discovery.
This is beyond basically the operative date. Is that kind of your argument here? That's
in a nutshell, Your Honor. Yes.
Okay. Response just on the operative date issue.
On the operative date, Your Honor, as counsel mentioned, we do have a summary judgment. They have not filed for summary judgment. So there's no finding that we are not a member. And furthermore, what we're going to get into with the other components, they did not follow the appraisal procedure that they must in the agreement. And it ultimately did not apply to us as we laid out in our summary judgment motion. Since we do not have a ruling Your Honor, it is safer to provide this documentation to us so we can take a look. This is not burdensome. This is something they can mark as confidential. And finally, Your Honor, there is no objection in their objections to being prejudicial. We have noted that it wouldn't be. You can file it as confidential. At the end of the case, there's a procedure to give it back. But Your Honor, as we're about to go into, they're not even sure whether or not they considered all the real property that's within this real estate investment company. They won't tell us what properties they did and didn't consider.
Sure, I'm remembering this correctly because I've had a lot of other cases. So this is the summary judgment about whether or not the plaintiff's motion for summary judgment, essentially, right?
That's right. And the defendants have not filed one. It was a member has not been terminated from the company. That's a dispute about member and about company, because the member is the trust that never had a job or employment, and the company is Side Holdings, not the staffing company.
So I apologize it took me so long to get you guys a ruling on this, but I'm going to go ahead and deny the summary judgment. So okay. I don't know if that helps resolve the issue. Have you guys submitted an order on that? No problem if you haven't, but
and Your Honor, if I may, even with the denial, that does not resolve the claim. They haven't filed a summary judgment to defeat our claim. The claim is still live that we are still a member entitled to these records. We have a breach of fiduciary duty claim. We're entitled to distributions that we haven't gotten. Those claims are still in the case, even with the denial of the summary judgment. So, and if they felt strongly about their reading and that we were wrong, I don't know why they didn't bother to file a summary judgment on their own. So, Your Honor, the claim is still alive. This is still relevant evidence to those claims.
Let me ask a question real quick, so we can resolve at least this summary judgment issue. When did you submit an order on that denying the summary judgment?
Yes, I believe we did, Your Honor.
When would that have been?
I'm happy to resubmit it as needed, but
let me see. I think we may have it. Let me see if I can share screen this. I think this is the right one, but let me just double check. Is that the correct order? Can you see it?
I can, Your Honor. I'm just giving it a quick read. Yeah, that appears to be correct. Yes, Your Honor.
All right. I'm going to go ahead and grant the motion to compel on this. All right, what's the next issue?
Okay. Your Honor, can I address one other thing that he said, or would you like to?
Why don't we move on to the next topic?
Okay, thank you, Your Honor.
Your Honor, the next bucket, we had put it 2 and 3 in our motion, but really it's the same bucket, and that is 2 interrogatories. One is a list of properties that Side Holdings held as of the date of the valuation, and then some corresponding information about what was the value of the property, where is it, what's its address. And the second interrogatory is, what are the real properties that the valuation firm BVA Group, which is now retained as a testifying expert for defendants, what real properties did they consider? Because at the end of the day, Your Honor, there is a procedure. Did Your Honor have a question?
No, go ahead.
Oh, I'm sorry. There's a procedure that you're supposed to give due consideration to things like the independent appraisals of the company assets, the financial records of the company, and so on and so forth. And in fact, one of the provisions the defendants cite in their response, they try to make it sound like BVA Group had unfettered discretion, but actually they kept putting an ellipses in that line. What they kept taking out was, any question about the valuation not otherwise controlled by the agreement. And Your Honor, if you don't mind me sharing my screen, I can show you that provision because it's very important about why this is relevant.
Okay, let me let you share screen.
Sure thing. This is on page 4 of our reply that we filed this morning.
Go ahead and share screen.
You got it. I will put that right up. This is page 4 of our reply, and we highlight it for Your Honor. So the last sentence is what defendants quote in their response several times. Any questions with respect to accounting procedures or valuations? They put in ellipses over controlled by this agreement, not controlled by this agreement, and they say shall be resolved by the accountant or appraiser. So the point is, what does the agreement control? Well, the agreement requires you to give due consideration to the financial statements of the company, independent appraisals of company assets, valuations of similar entities, so on and so forth. So in other words, while the appraiser has discretion to do many things, the appraiser can't go fully rogue. The appraiser can't do things like, I don't know if I considered all of the real property in this real estate investment company, but I've done a good enough job. Your Honor, that is one of the critical arguments that we're making is her report says that there's over 25 properties. Okay, that's not even an exact number, but it gives you a range. And each of these properties is worth multiple millions of dollars each. And the Tim Seib Trust owns 25% of the company. Missing even a single property, that's real dollars. That's a big deal. And furthermore, if they have not followed this procedure, they cannot use it as a binding valuation to force the buyout. So that is why we need to be able to put it side by side. What did you own at the time and what did they consider? And Your Honor, they've said, oh, we've produced all these documents. They haven't identified it by Bates label, but Your Honor, I want to be clear. I don't want just Bates labels. When we go to trial, and Your Honor denied the summary judgment, so that seems likely, I want to have the clear list of properties so that we don't whip out one of the documents and they say, oh, you're misreading that. We didn't own that. That was this or that. We needed a definitive list of the properties so we know exactly what they own and what their testifying expert considered.
They've already produced these documents. Is that correct?
I'm sorry, Your Honor, I didn't hear the question.
Can you hear me okay?
Yes, I'm sorry. I just missed it on the first pass. Can you ask me one more time?
So they're arguing that they've already produced these documents, correct?
They appear to be, but did not give the Bates labels. And Your Honor, here's the other issue. They seem to be pointing.
Oh, go ahead.
Oh, I'm sorry.
No, go ahead.
They seem to be pointing to certain tax appraisal district documents. But again, there's more than 25 properties, and it's not just the memory care facilities. There is a corporate headquarters. They own a bank. There's witnesses that weren't clear how many bank locations there were and whether they were owned by the bank. That's why we need a definitive list. What do you own? What is it? Where is it? What do you understand the value to be? So we got to have these two lists for these two interrogatories. Oh, and by the way, Your Honor, what they're saying is they responded to these interrogatories by acting like they were requests for production and saying, well, we don't have a list of our real properties. Your Honor, I find that to be a bit incredible with a real estate investment company, but they have accounting software that they should be able to go through and pull this information together. So all their cases about requests for production are not on point and are not controllable.
Response?
Your Honor, may I share something as well as part of my response?
Sure. Just give me 1 second.
Thank you.
No, go ahead.
And I'll go ahead and start because I'm going to start somewhere and then get to what I'm going to share. But well, Your Honor, the simple answer to it is that no such list exists. And as I'm sure the court is aware, Texas law does not require a party to create a list in response. And I find it kind of funny that there's this argument, oh, this is really a interrogatory and not an RFP. Plaintiff's own reply this morning on page 3 states that my client can, quote unquote, go through its records and pull together a definitive list of its properties it owns. Not to mention, these are records that have already been produced to plaintiffs to begin with that they themselves can go through and create as well, but apparently they don't want to have to do that. So as far as what's been produced, though, Your Honor, so let's just be clear, thousands and thousands of pages of financial documents, including ledgers containing the entities, CAD appraisal reports, property tax statements, the entire working file of the appraiser, and what real estate documents she reviewed. She also has been deposed, Your Honor, meaning Miss Laura Lee White, who's with BVA. In her deposition, she stated that spreadsheets were produced, quote unquote, listed out real property owned and by which entity. In addition to that, let me share this. as far as this contention, I mean, this is Miss Laura Lee White's deposition, as far as this contention that she didn't have everything to go through, that's entirely untrue, Your Honor. It was discussed at deposition. It's discussed right here in the deposition. Giving due consideration to first the financial statements of the company. Yes, sir. Did you do that in creating your valuation? Yes, sir. Independent appraisals of company assets. Yes, sir. And you have seen the independent appraisals that have been produced here in the deposition today. Yes, sir. And you've already testified those appraisals did not change your opinion. Is that right? That's correct. These are additional documents that plaintiff's counsel claimed in his reply that he was complaining about, Ms. White not having the entire list of real estate. They had a discussion after that. She testified later on in her deposition that her and Mr. Goolsby and plaintiffs discussed what else they claimed was not included in her evaluation. And she stated, and she resolved any of those potential issues, as was her right under the company agreement. And there were no issues whatsoever as related to the valuation. So, Your Honor, a couple of things. I mean, one, yes, it's been produced. They just don't want to go through the documents. And two, there's no such exact as list. We'd have to create that list, which is not a requirement under the rules of discovery in Texas.
What I'm going to require you to do is you said you've already produced it, identify by Bates label what is responsive to this particular request. And if there's different properties, which property, like let's say there's the ABC Bank documents and they're responsive to this, say the ABC documents are at Bates numbers this. And if it's, XYZ Bank, then their documents are at this level, at these Bates numbers.
Right.
Identify by, you don't need to make a list, but you need to identify all the responsive documents by Bates number.
All right. And I apologize, Your Honor. I am having a little difficulty hearing you, but I'm pretty sure I heard you. So give them the Bates ranges.
Yeah. So each particular responsive entity, I guess, that you're responding for, like these documents related to ABC Bank, you would do these Bates numbers. These are responsive to Bank. You'd use these Bates numbers.
Okay.
Are you able to hear me better? I'm using a different computer right now.
I can. It has been a little low throughout the hearing, Your Honor, but I can hear what you're saying. So
okay, let me see. Maybe the sound is low on this. I'm not used to using this computer.
Yeah, Judge, it's real choppy.
And the speaker is at 100%, so this is really hot. All right, what else do we have? We gotta get to the next. What do we have next?
I have one more thing, one more category, but I just want to make sure, Your Honor, just to clarify Your Honor's ruling, I want to make sure that I don't just get a jumble of Bates labels. Your Honor, are you saying that they need to identify by property? Say, here's the property one, property two, like that?
Correct, or by entity.
Thank you, Your Honor.
Your Honor, that's going to be incredibly onerous, I have to tell you, because I mean, these documents are all, I mean, like I said, there was a spreadsheet with BVA's valuation included. There's some it's to separate those by specific properties, essentially, getting around the fact that we would make a list. So, I mean, I'm happy to give them Bates labels, like where they list the properties.
Counsel, make my ruling. Let's move on to the next one. Okay.
Yes, Your Honor, final category is a request for production related to professional expenses. That's a category of charges that appear in the general ledger. That is a deduction that was used during the valuation. And we have asked for the backup documents that should appear in their accounting software. These professional expenses were incurred prior to August of 2021. That is when a time period in which no one disputes that the Tim Seib Trust was an owner of the company. And as Your Honor knows, under the Texas Business Organizations Code, even when you're a prior owner, again, we contend we are a current owner, but even when you're a prior owner, you have access to the business records for the time period in which you were an owner, even into the future. So that's one reason we should get it. That's something we pled. And then, by the way, that's at issue regarding the valuation. Did they give due consideration? And ultimately, did they use the funds correctly? Or was it some kind of improper distribution to the other trusts? And that's why we were seeking those documents, Your Honor.
Response?
Your Honor, there's been no allegation whatsoever that any of the professional expenses identified in the Side Holdings general ledger were improper. As a matter of fact, they were looked at by Ms. Laura Lee White with BBV, and she specifically again testified that she had no concerns about them whatsoever. This is again just trying to muddy the waters after the fact. Again, they agreed to the appraiser. We used their suggestion for the appraiser. That appraiser resolved any issues potential issues as it relates to these these professional expenses. She testified, she gave all due consideration to those documents. There's no reason to compel further background on those documents other than the general ledgers that we've already produced that show these specific professional expenses. If he has a problem with them, he can take issue with each one.
Is there an allegation, Mr. Goolsbee, in this case that there was something inappropriate distribution as the professional expenses? I didn't get that impression.
Yes, Your Honor, and we were more clear about that in our reply file today. What we attached, Your Honor, was objection letters that we had provided to BVA Group and defendants during the valuation. And we said, hey, these professional expenses look wrong. We're not clear what's going on with that. Will you tell us what's going on? Again, we've attached 2 letters that were sent before the report was finalized. And when defendants are saying that Lori Lee White said that she looked at them and said it was all okay, I'm not sure what testimony or what passage he's referring to there. But in any event, we put that allegation forward. Your Honor, I do want to stress that we don't have to, even though we do have a reason that it's wrong, that's Exhibit 11 to our reply file this morning. At the end of the day, we actually don't have to allege anything that's wrong because we were, and this is undisputed, that Tim Side Trust was an owner during that time period. These charges would also be books and records. Your Honor can grant it for either reason.
Your Honor, real quick, that attaching something to a reply is not an allegation. There is no allegation specifically as it relates to that. And
let me ask this, Mr. Goolsbee, anything in your pleadings that indicate that this is an allegation, not in your reply brief?
Oh, I'm sorry. Do you mean in the motion to compel, Your Honor?
In the pleading, in your petition or answers or?
Oh, yes, Your Honor. We've asked for the books and records of the company. We have a claim under the Texas Business Organizations Code, and that should be paragraphs 92 through 97. I know it was in the paragraphs were in the 80s for the breach of fiduciary duty and the misuse of company funds, breach of contract for not following the valuation procedure. Your Honor, I'd have to go look at the petition to see if professional expenses was directly used. But Your Honor, we raised this with BVA Group while they were doing the valuation and said, hey, you need to look at this. So now they're saying that they had looked at it and said it was okay. That's news to me, Your Honor.
I mean, again, Your Honor, it's not in the pleadings that I'm aware of. And again, we've given them general ledgers that show those specific items. So they have the documents that show what those expenses were.
I guess you're talking about invoices or billing invoices or things like that. That's what you're looking for, Mr. Goolsbee.
So Your Honor, yeah, we need the underlying invoices because what the general ledger does is it has one category that just says professional expenses. I can't see, and I believe, Your Honor, it's about $2 million or so. And I'm looking, Your Honor, as we talk to see if I have professional expenses. Actually, Your Honor, I do have professional expenses on paragraph 8 of our petition. Large professional expenses amounting to millions of dollars that plaintiff are concerned are improper distributions taken by various defendants, and it goes on. So, Your Honor, we have actually pled professional expenses in paragraph 8.
All right, I'm going to go ahead and grant the motion to compel, provide just invoices, nothing, no additional background, but any invoices provided by professional, and whether it's attorneys or accountants or whatever, you don't need to provide anything beyond the invoices or the billing records if there's billing.
No, it was really hard to hear that. I apologize again.
Okay, so can you hear me okay?
That's a little better, yes.
Yelling, it seems like this is a different computer, so I'm not used to
Sure.
People usually can hear me. So you're going to be required to produce those. You only need to produce the invoices, not any other additional documentation. I need you to get me an order on this. I've already signed the summary judgment order. If you get me an order on this, Mr. Goolsbee, share a copy of the order with Mr. Catalano. make sure the order at the says that this was heard on October 24th, 2022, as opposed to on this date. And I would like to get a copy of this order by tomorrow morning. Okay,
All right, thank
you
you.
guys have a great rest of your day.
You too. Thank you.
All right. Fisher v. Fisher, we're here on a motion. We have quite a few hearings this morning, quite a few people here, so I need to kind of move through these. We're here on a motion for continuance. Is that correct?
Yes, Your Honor.
Correct.
All righty. Do y'all want this on the record or no?
Yes, please.
Okay, let's go on the record. Tony, are you ready?
Yes, Judge.
So on the record on DC 19-17340, Fisher v. Fisher, counsel make your appearances.
Your Honor, Kyle Gardner and Mike Lynn for Gail Corder Fisher. Larry, you're muted.
Guys, we need somebody to talk.
There we go.
All right, Larry Friedman, Leon Carter, Seymour Roberts. Let's see who else. Courtney Perez. Who am I leaving out?
Alan.
Now, Alan, you have your own parties.
Yeah.
Well, Cliff Fisher and Company and Cliff Fisher individually, and I'll turn the floor over to Alan Lowenson.
Good afternoon, Your Honor. Alan Lowenson representing Ted Uzelak and Larry Teal.
Okay, let's hear argument.
All right, Your Honor. So we filed the motion for trial continuance based on a conflicting trial setting that Mr. Lynn has at the start of November, and also an upcoming surgery that he has on December 1st. If you'll recall, on September 12th, we had a hearing on the special exceptions. During the course of that hearing, we discussed Mr. Lynn's upcoming surgery and conflicting trial setting. You instructed the parties to confer a potential continuance. On September 14th, the parties held that conference. And during the course of that conference, Mr. Lowenson, representing Mr. Uzelak and Mr. Teal, agreed to a continuance. And during the course of that same conference, Mr. Friedman, and I believe Mr. Roberts was on the call, I'm not entirely sure if he was, said that they would need to confer with their client prior to agreeing to the continuance. Importantly, during the course of that phone call, at no point was it intimated that Mr. Lynn's necessity for a surgery was somehow a lie or strategic, although if you've read the responsive briefing, that is what the allegation is now. We were informed a few days after that conference that their client would be opposing the continuance, and now we've received the response wherein it's alleged that Mr. Lynn's surgery in part is a strategic maneuver. We're seeking a brief continuance until the last week of February. During the course of that conference call, at least at the time, that was an amicable date for the parties for that proposed continuance.
Mr. Gardner,
Yes, Your Honor.
what was the date?
Oh, February 28th, the week of February 28th. I believe that's a Tuesday in February. I could be mistaken, but that was the proposed date. With respect to the arguments that were made by opposing counsel in the response, there was the one argument made regarding the local rules. We've corrected this issue. We have a signed writing from Ms. Fisher consenting to the continuance due to the case being pending.
I already have a special setting on February 28th. Did no one check that?
I can't do it then anyway, Your Honor. I can tell you.
It's and Mr. Friedman, is it a different Mr. Friedman on this case? Are you on this case, Mr. Friedman, Roberts v. Manning, or is that a different Friedman?
That's maybe a different Friedman. I'm on the Fisher case. February 21st is a good date for me, Your Honor. Is that available in your calendar?
Let me
But
see.
look, Your Honor, no one's challenging Mr. Lynn's medical necessity. Although that was the only cause for continuance brought up at the special appearance hearing. Now, apparently, there's jockeying between his surgery and conflicting trial schedule. I'll leave that between Mr. Lynn, Mr. Gardner, and Mr. Carter to explain that to you, because Mr. Carter's involved in the other case. But here's the issue. This is the real issue. When Mr. Lynn got in this case back in November, the representation was made that it would not be cause for delay. Shortly thereafter, all of the scheduled dates, according to the trial schedule, elapsed. And when they asked for continuance the first time, moved this case to April, the court did not reopen any of the scheduled trial dates. One, I want to make sure that none of the scheduled trial dates, none of the dates in the scheduling order for discovery, designations, or anything else gets reopened because we're accommodating Mr. Lynn and his client again. And as importantly, apparently, as you know, there's parallel case pending in the family court. And there is some discovery that the Lynn firm is attempting to take in the family court. What I want to be sure is that there's no backdoor attempt to use that discovery in this case, because the court's made it clear that all the discovery deadlines have passed, the dates have passed, discovery is closed. The auditor's report has come in, it's final. And what I don't want to do is reopen the discovery in this case through a side door and then yet again have cause for another continuance after we reset this case again. I've been seeking an agreement stipulation from Mrs. Fisher and her counsel that none of the discovery, if any, that was determined in the family case would be used in this case. And I can't get that, which leads me to believe that there's a strategy that would allow them to use that discovery in this case. So if I can get that stipulation, we're good to go.
May I respond, Your Honor?
Yeah.
Well, I don't understand the argument. There are two arguments I'm hearing. The first is that somehow, some way I concocted the December 1st operation. I see that Larry is now backing off of that. That's just not true. I let everybody know this as soon as I got
Say it again, I
cleared.
lost you.
And I was cleared in September to have the operation December 1. I need to get the operation out of the way. Unfortunately, I'm getting older and things break or don't operate the same way they should. The second thing is that somehow I'm conspiring against them because I'm seeking discovery out of the family court. That should not enter into the court's decision. That is an issue that's taken up with the family court. To the extent there are admissions or otherwise admissible evidence, that's something the court can deal with at trial. It's not something where I don't think it's wise to preclude evidence that might be relevant to this proceeding that I get through other means. And that's what they're trying to do. I believe that you don't have jurisdiction, and according to the mandamus that I've read, to deal with restricting anything going on in the family court. I don't think it would be wise to do that anyway, but certainly you're not going to. I don't think they're asking you to sit as a family court judge and preclude what comes in this court. But the decision, if they file motions in limine on me at trial and say that I can't prove up something as true that we know is true, that will be relevant to the proceedings in your court, that is not something this court ought to make the decision on, I submit, at this juncture. It makes no sense whatsoever to try to extract that kind of promise from me. And I'm just not going to give it, because if there is true testimony from any of the witnesses that would go to the allegations in this court and they are otherwise admissible, then the court can rule on that at trial, which you almost always do. That's the way we have always done things.
So let me
So
just-
here,
Well, Judge, can I
Wait,
respond?
Wait, I'm talking, so let me talk and then you guys can talk. So let me just say this. I'm not going to try to restrict what the family court does. I agree with that. I'm not trying to sit as a family court judge. Whatever the family court judge does is fine. What I am concerned about is this surgery being used, not intentionally necessarily, but we would go to trial on this case in December, but for the surgery. If there's things that happen, and I've done this in other cases, I think Mr. Carter actually was in one of these cases, where I basically set a case at amber. And what I mean by that is that in fact, I think some of you guys, besides Mr. Carter, have had this happen. I basically say no other discovery, nothing else happens on this case when there's a continuance caused by one side or the other's medical condition or something like that. And so I agree, I'm not going to restrict what's being done in the family court. If the family court lets discovery occur or issues orders, I'm not trying to interfere with that. I don't want moving this trial to work as a benefit to one side or the other, especially if it's somebody who is moving for continuance because of their own situation. I'm going to honor that, but I'm not going to allow it to be an advantage to one side. So what I would suggest doing at this point, or I'm not going to suggest, what I'm ordering at this point is any discovery that occurs after this upcoming trial setting. So what is the trial setting right now in December?
November 29th, Your Honor.
December 20.
No, November 29th is the current.
Any discovery, anything that happens after November 29th, we're set in amber. There's no additional discovery, no additional motions, nothing else happens in this case after that date. So we're basically setting the case in amber. Nothing else is going to happen until we get to whatever the next date for the trial is. So that the surgery cannot be used as a sword. It can be used as a shield, but not as a sword.
But it's not being used either way. I have a case going in a parallel jurisdiction where the court is making decisions that I'm permitted to go forward. Now, let's assume we have a simple fact. Let's assume for a moment that, and I don't mean this to be, let's call it something else, Jerry Lewis instead of Cliff Fisher. So Jerry Lewis murders his wife, okay? And I am able to prove that up between now and the time I go to trial in the family court on a contempt issue. And that issue is somehow relevant to a case before you. Then it makes sense that they ought not to be able to deny that that Jerry Lewis murdered his wife.
So let me make one caveat to this. I'm not sure exactly what your hypothetical is, but let's say that something occurs during that time period from, so let's say hypothetically, Cliff Fisher, how does that old song go where she scrapes her keys along the side of it? Who's that famous country western singer? She scrapes her keys along the side of the pickup truck or whatever. Let's say that Cliff Fisher comes and scrapes his key along the side of Gail's pickup truck, and that's a new thing that happens during that time period. Then yes, we can discuss having discovery over something new that happens during that time period. But I'm not going to allow you to, and I totally disagree with you, Mr. Lynn, if you get some other discovery after this trial setting, then you are able to use your surgery as a sword because you wouldn't have been able to get it otherwise. And so
Judge,
We're going to be offering it we'll make proffers of it anyway. I mean, that's just the nature of it.
I'm not going to give it continuance if you're going to do that. I mean, you're trying to use this as a sword then.
No, I'm not. I'm just
Judge, may I be heard?
So go ahead.
What we're trying to do here, Judge, is maintain the status quo. Because right now, if the trial happens on November 29th, it'll happen before any discovery that they want to take in the family law case. And what we're trying to do is to freeze everything so that Mike Lynn can get better. He should have all the time he needs to recuperate at home, occupational therapy, physical therapy. But what we're afraid of him doing is taking discovery after the trial date and then using it in our case when he couldn't have done it otherwise. Remember, Judge, remember that when Mike Lynn filed his notice of appearance, he had 74 days to conduct discovery and fact discovery and depositions, and he never did it. And what he's doing now in the family case is making up for the things that he didn't do in this case. And I'm not saying that he planned his surgery to do that.
Mr. Roberts, I 100% agreed with you. So, but so you're kind of repeating what I said. Maybe it's hard to hear me. I've heard some people say it's hard to hear with this computer. But the concern I have, Mr. Roberts, now is that Mr. Lynn is saying, okay, I understand, Judge, you're going to make this order. You're going to give me a break. I'm going to let you, I'm going to continue the case, but now I'm going to use this as a sword at trial and try to use this, and I'm so proffer, and we potentially have to try this case again. I don't know that I want to respect Mr. Lynn and his medical condition, but basically telling me, you know what, I'm going to use this as a sword because I'm going to proffer the whatever evidence I get in the family court during that time period, and I'm going to try to create reversible error. I think that's using it as a sword. I don't know that I can continue this case.
Judge Hoffman, can I say something very quickly? The discovery's already been ordered in the family court case. I think based upon what you previously ordered, that anything after November 29th date, right? Mr. Roberts, similarly should not use this continuance in that current order as a shield, or a sword rather, and drag his feet through his rolling production that he was ordered to make months ago. That's the only thing that I would say. So long as he fulfills his discovery obligations and we're allowed to use whatever we received prior to November 29th, and we can file appropriate motions up until that point, should Mr. Roberts elect to drag his feet through the rolling production in the family court. I would say, Your Honor, that's a fair thing, but just so long as we maintain the original trial setting as the cutoff.
Well, the problem with that is that the discovery deadlines in the family court case expired January 31st of 2022.
Seymour,
I'm not finished, Kyle. When I'm done, you can talk.
I will.
So as far as taking depositions, for example, you shouldn't be able to use your depositions that you take now in the family court case because you never took them in Judge Hoffman's case.
Your Honor, respectfully, the trial is November 29th. If we take a deposition prior to that point, that's the current posture of the case.
That's a totally separate issue, to Mr. Roberts.
Thank you.
That's a totally separate issue.
I'm going to ask the court to deny the motion for continuance.
You want me to deny the motion?
Yes, because there's no other way around it. Otherwise, the Lynn firm and Gail Fisher is going to use this to create reversible error. So let's all scramble, get ready for trial. And initially, look, everybody wants Mr. Lynn to get the medical treatment that he's entitled to, and we want him to get better. But initially, this was about Mr. Lynn's medical condition. Now it's about a conflict so he can go try a case in Midland. Well, this case to us is more important than the case in Midland. Case in Midland is someone else's problem. So I'm going to ask that you deny the motion for continuance. Let's try this case on the 29th.
I can't try it on the 29th. I will not be here on the 29th because I just can't physically make it. So
are you going to be in surgery, or are you going to be in trial in Midland?
I'm not going to be in trial in Midland. The Midland trial will be over by the 15th, I think, if it even goes, because there's some motions that I think may preclude that case from going until an appeal is taken. So we'll sort of see how that.
Wait, so when is the surgery again? What date?
December 1st, Your Honor. I'm not going to be December 1st. And so November 29th, the case before you is going to take more than 1 day to try.
No, I mean the Midland trial, when is that?
It's set November 7th.
Okay, all right.
And so it doesn't conflict with this one.
Yeah, that's not a conflict.
Your Honor, the only reason it was mentioned is we did discuss that during the September 12th hearing. Contrary to what Mr. Friedman said, we did discuss the potentially conflicting trial setting had that trial run long. But I think the only thing that I want to say is that I think it's a perfectly reasonable, middle ground for us to stay in discovery on the 29th, but that is freezing the case in amber. That's how it currently stands.
But okay, so the only concern I have, Mr. Gardner, and it's a serious concern, is the statement made by your partner, Mr. Lynn, when he said, can you hear me okay?
Yes, Your Honor, I can.
When he said that we're going to proffer information that we get during that time period. And if that's the case, then I agree with Mr. Friedman. We're just creating potential reversible error. and then we should just go forward on the 29th. I mean, I'm trying to respect Mr. Lynn, but I feel that this is clearly being used as a sword. And so what I would suggest we do at this point is, why don't you guys confer with each other, you and Mr. Lynn, and which side is Mr. Carter on? Are you on Mr. Lynn's side or Mr. Friedman's side?
Mr. Friedman's side.
I want Mr. Friedman.
Okay.
Cliff Fisher. I represent Cliff Fisher, Judge.
Yeah, I was a little confused based on a couple things that were said. So,
I represent Cliff Fisher.
well, whose side are you on here? If we can get an agreement that we're not going to, this statement about we're going to make proffers about information that we would receive during that post November 29th trial date, that is not going to happen, and that's going to be part of the order, and you guys are going to agree to the order, then great. Otherwise, I think we have to go forward on the 29th. I want to respect Mr. Lynn. I do respect Mr. Lynn, but I don't respect that. I feel it's extremely problematic to be able to try to use information that's obtained during that time period, because you're then using this surgery as a sword.
That's understood, Your Honor. The only clarification that I would ask is that, you know, we're not talking about the separate issue of things received prior to November 29th, correct? Okay, thank you.
Or not November 29th, that's fine. If you have some issue in the family court about them dragging their feet, that's between you and the family court.
Absolutely.
Anything before the 29th is not necessarily admissible, but it's not state and amber.
It's not verboten. Yes, Your
It's
Honor.
not
Understood.
verboten. So you guys try to work it out. You get an order for me. If there's an issue with the order, let me know, and we can talk about it until we get an agreed order on all of this. The trial setting has stayed in place, but once we get an agreed order, Mr. Roberts, I assume that you will work in good faith with Mr. Gardner to try to work this out.
Judge, I'll circulate a proposed agreed order, and we will go from there.
Your Honor, do you have February 21st available?
Oh, that's a good.
Yes. Yeah.
Okay, so it would be a lot better for me if we could do February 14th.
And I'm sorry, Your Honor, I can't. I've got another trial that week.
Okay.
And I can't either.
And my problem is I have how long is this case going to take to try?
Depends.
It depends on how much summary judgment is entered beforehand.
Okay. Assuming there's no summary judgment entered, I'm not saying there won't be, but assuming there's not, how long is it going to take to try?
2 weeks.
So my issue is I have a special setting on the 28th. That's my issue. And so I don't know how long it's going to take. It's the one that the other Mr. Friedman is on. It's Robert. It's a medical malpractice case, Roberts v. Manning. So that case is specially set. So I don't want to interfere with that case. So
What about March 28th? I don't know what everybody else's availability is.
let me see.
Excuse me, Your Honor, I am in that case. It doesn't look like that case is ripe for settlement. So as of now, that case is going to trial.
The medical malpractice cases?
Yeah,
Okay. And you're the defense attorney on that?
one of them, yes.
Oh, wow. Okay. March 21st would be better.
Yeah, and I'm sorry. I know I'm the first one speaking up and others may have conflicts, but I can't do the 21st.
Alan, is there any time earlier in March that would be?
I can't do it in early March. Early, mid-March, I'm going to be out.
How about April 18th?
Just give me a second.
I can do that.
I'm sorry, I need to pull that up. At what day? Is
April 18th.
Does that work for everybody?
Does for me.
Let me just check.
For me.
Yeah, April 18th works for me too.
Okay.
All right, great.
Special settings on the horizon.
Is this a special setting, Your Honor?
I mean, so let me give you my special setting speech. Some of you have already heard this before, but I'll make sure everybody's on the same page. If I said it April 18th, there is no moving it. unless an attorney dies or a party dies. So, and it has to be lead counsel. You are set in stone. It will not move. And so are you sure you want a special setting? Or maybe you guys should confer on that, because then it's set in stone and it does not get moved. You all want to talk about that first? Or I can set it the April 18th, and then you guys all agree I can specially set it.
Let's confer first. That way we can double check calendars before we overly commit to anything.
We have experts and they have experts, and I'm sure there's going to be other people we have to consult.
All right. Rhonda, are you there? Rhonda,
Yes,
go ahead and reset this case to April 18th. Do not specially set it at this point. If they file an agreed, put in the notes, if they file an agreed special setting request, we'll specially set it. But
Okay.
Wait, Alan's saying something and he's muted.
You're muted, Alan. Let me say
Yeah,
one.
sorry.
Wait. One last thing. If another case requests a special setting on that day, then that case will go ahead of you. So just be aware of that if you wait too long to request a special setting. Go ahead.
We'll move expeditiously, Your Honor.
So just to clarify, as I understand where things are left, it is still set for November 29th, but if we get an agreed order to you on continuance by all sides, it will be moved to April 18th.
Correct. You're exactly right.
All right.
But get me that as quickly as you can.
We will, Judge.
And Mr. Roberts, you've heard this speech a million times. Remember, at the beginning of the order, it should say this was heard on October 24th. Give me the order if you can by this Friday.
I'll do it, Judge.
Thanks, you guys. Have a great rest of your day.
Thank you, Your Honor. Appreciate it. Bye-bye.
Okay.
I don't know how to turn it off. So if you can figure that out for me.
Okay, our next hearing is the Ruiz v. Cunningham case. Are both sides here on that?
Yes, Your Honor.
Good afternoon.
Yes, Your Honor.
Let's go on the record on DC. Tony, you ready?
I'm ready, Judge.
DC 21-10413, Ruiz v. Cunningham. Counsel, make your appearances.
Azam Mandavia appearing on behalf of plaintiffs.
Luke Calvert appearing on behalf of defendants April Penny and Michael Cunningham.
Matt Mulkey appearing on behalf of defendant Victoria Ruiz.
Maria Sevas appearing as the guardian ad litem for the minor children.
All right. Is that everyone?
Yes, Your Honor. We do have a translator, Your Honor, a Spanish interpreter.
All right. Let's get started. Go ahead and call your first witness.
Thank you, Your Honor. At this time, plaintiff calls Rosa Ruiz as his first witness.
Okay. If I could have the translator to please raise your right hand. Do you swear or affirm that you'll faithfully translate the matters in this case from Spanish to English, English to Spanish, to the best of your ability, so help you God?
Yes, I do, Your Honor.
Okay. And please state your name and your license number for the record, please.
Yes, my name is Mirna Ramirez, license number 1667.
Go ahead. Let's get started.
At this time, plaintiff calls Rosa Ruiz as his first witness.
En este momento, el demandante llama a Rosa Ruiz como su primer testigo.
Mr. Ruiz, please raise your right hand.
Señora Ruiz, ¿puede alzar su mano derecha, por favor?
Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
¿Jura o afirma que el testimonio que está a punto de dar va a ser la verdad, solo la verdad y nada más que la verdad?
She's muted.
Señora, tiene que encender su micrófono.
Did she still hasn't answered yet.
¿Ya respondió? ¿Puede decirlo otra vez?
Sí.
Yes.
Let's proceed.
Good afternoon.
Buenas tardes.
Are you Rosa Ruiz?
Sí.
¿Usted es Rosa Ruiz? Yes.
Are you the next of friend for minor ELM and minor LRM?
¿Usted es la amiga cercana de el menor ELM y LRM? Perdón, no le escuché. ¿Usted es la que dijo? I'm sorry, I couldn't hear you. You said the what?
Are you the next of friend for minors ELM and minor LRM?
Usted es la representante de los menores ELM y LRM. Sí. Yes.
Were the minors involved in a motor vehicle collision on August 8th of 2019?
Los menores estuvieron involucrados en un choque vehicular el 8 de agosto del 2019. Sí. Yes.
Was minor ELM 11 years old at the time of this collision?
Al momento de este choque, la menor o el menor ELM tenía 11 años de edad. Sí. Yes.
Is minor ELM 14 years old now?
Ahorita tiene 14 años de edad la menor ELM. Sí. Yes.
And was minor LRM 1 years old at the time of this collision?
Y cuando sucedió este choque, el menor o la menor LRM tenía 1 año de edad. Sí. Yes.
And is he 4 years old now?
Y ahora tiene 4 años de edad. Sí. Yes.
Were the minors injured as a result of this collision?
¿Los menores salieron lesionados como resultado de este choque? Sí. Yes.
Did minor ELM receive medical treatment in connection with this collision?
¿El menor ELM recibió tratamiento médico relacionado con este choque? Sí. Yes.
Did minor LRM receive medical treatment in connection to this collision?
¿También el menor LRM recibió atención médica relacionado con este choque? Sí. Yes.
Is medical treatment completed for both of these minors?
¿Para ambos menores ya se completó la atención médica? Sí. Yes.
Is minor ELM in reasonably good health today?
Al día de hoy, el menor o la menor ELM está en una condición saludable, razonable. Sí. Yes.
Is minor LRM in reasonably good health as of today?
Al día de hoy, el menor LRM también está en una buena condición de salud, razonable, al día de hoy. Sí. Yes.
Do you understand that we are here to approve of a settlement in this case?
¿Entiende usted que estamos aquí para aprobar un arreglo, un acuerdo en este caso el día de hoy? Sí. Yes.
And do you understand that the court has appointed a guardian ad litem to represent each of the minors in this case?
¿Y usted entiende que el tribunal, el juez, ha designado a un guardián o custodio ad litem para representar a cada uno de los menores en este caso? Sí. Yes.
You understand that by agreeing to settle, you are waiving the minor's right to a trial.
¿Y usted entiende que al llegar al acuerdo el día de hoy, usted está renunciando al derecho de que los menores vayan a juicio? Sí. Yes.
And you understand that by going to trial, the minors could have gotten more, the same, less, or nothing.
¿Y entiende usted que si fuésemos o si fuéramos a juicio, los menores pudieran obtener más, la misma cantidad, menos cantidad o nada? Sí. Yes.
And you understand that the gross settlement for minor ELM is $7,000.
¿Y entiende que el acuerdo bruto al que llegamos para la menor ELM es de $7,000? Sí. Yes.
And you understand that the gross settlement for minor LRM is $800.
¿Y entiende que el acuerdo bruto al que llegamos para el menor LRM es de $800? Sí. Yes.
And you understand that the breakdown of the settlement for minor ELM is as follows. $1,785 to be paid to past medical providers.
Y entiende que el desglose para el menor ELM de esa cantidad es el siguiente. Van a ser $1,785 para lo que es proveedores de atención médica del pasado.
Sí.
Yes.
and $155.32 to be paid to Medicaid,
Y $155.32 para Medicaid.
Sí.
Yes.
and $2,454.57 to be paid as attorney's fees and costs.
Y lo que son $2,454.57 que se van a pagar para honorarios y gastos legales.
Sí.
Yes.
And you understand that the remaining $2,605.11 is to be placed in the registry of the court.
Y entiende usted que el resto de la cantidad, que son $2,605.11, se van a colocar en el registro del tribunal.
Sí.
Yes.
And you understand that that money is for minor ELM for when she turns 18.
Y entiende usted que ese dinero es para la menor ELM para cuando cumpla 18 años de edad.
Sí.
Yes.
And you understand that that money is not for you or anybody else and only for the benefit of the minor.
Y entiende usted que ese dinero no es para usted ni es para nadie más, es únicamente para el beneficio del menor.
Sí.
Yes.
And you understand that out of the gross $800 settlement for minor LRM, $60 are being paid for past medical bills.
Y entiende usted que de la cantidad bruta de $8,000 para el menor LRM, $60 se pagaron para atención médica pasada. I'm sorry, counsel, did you say 8,000 or 800?
800.
I'm sorry, the interpreter takes that one back. Es 800, señora.
Okay.
Okay.
And you understand that $316.87 are being paid as attorney's expenses and fees.
Y entiende usted que esa cantidad, $316.87, se están pagando para gastos legales y de abogados.
Sí.
Yes.
And you understand that the remaining $423.13 is being placed in the registry of the court for the benefit of minor LRM.
Y entiende usted que la cantidad restante de $423.13 se están poniendo en el registro del tribunal en beneficio del menor LRM.
Sí.
Yes.
And you understand that that money is not for you or for anybody else and only for minor LRM.
Y entiende usted que ese dinero no es para usted ni es para nadie más, es únicamente para el beneficio del menor LRM.
Sí.
Yes.
Are you asking the court to approve of this settlement?
¿Usted está pidiendo al juez que apruebe este acuerdo?
Sí.
Yes.
I pass the witness, Your Honor.
Cedo al testigo, su señoría.
Mr. Calvert?
I have no questions.
Mrs. Davis?
There is another defense attorney, Your Honor, Mr. Mulkey.
Mr. Mulkey, do you have any questions? I apologize.
No, it's okay, Your Honor. No questions. Thank you.
And briefly for me, Your Honor. Ms. Ruiz, you and I actually had an opportunity to meet before today, correct?
Señora Ruiz, usted y yo tuvimos la oportunidad de reunirnos antes del día de hoy, ¿correcto?
Sí.
Yes.
And you understand that I am the guardian ad litem that was appointed to represent the minor children and their interests in this matter.
Y usted entiende que yo soy la custodia ad litem que fue designada para representar a los menores y a sus intereses en este caso?
Sí.
Yes.
During the meeting, we talked about the minor's accident, the injuries, and the settlement, among other things, correct?
Y entre otras cosas, cuando nos reunimos, hablamos acerca del accidente, las lesiones de los menores y el acuerdo al que se llegó, entre otras cosas, ¿correcto?
Sí.
Yes.
And are you asking the court to approve this settlement because you believe it's in the best interest of both minor children?
Y usted le está pidiendo al juez que apruebe este acuerdo o este arreglo porque usted considera que es en el mejor interés de ambos menores?
Sí, señora.
Yes, ma'am.
No further questions, Your Honor. I pass the witness.
No tengo más preguntas, señoría. Cedo al testigo.
Is there any additional questions from any party?
No, Your Honor.
No, Your Honor.
No, Your Honor.
Is there a recommendation of the guardian ad litem?
Your Honor, we do have one more witness. It should be a brief, very brief question.
I apologize, Your Honor. Plaintiff would like to call Victoria Ruiz to the stand as the witness
Where is she?
on the same video as Ms. Rosa Ruiz.
Does she need a translator as well? Or no?
Yes.
Okay. Please ask her to raise her right hand.
Actually, can you have Rosa put Victoria on, please?
Señora Rosa, necesitamos ahora hablar con Victoria para que le hagan las preguntas a ella. ¿Está ahí?
Sí.
¿Necesita alzar su mano derecha?
Ma'am, please raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Señora, ¿jura o afirma que el testimonio que va a dar va a ser la verdad, solo la verdad y nada más que la verdad, Dios mediante? Yes.
You are Victoria Ruiz, correct?
Usted es Victoria Ruiz, ¿correcto?
Sí.
Yes.
And did you understand the questions that Rosa Ruiz was asked today?
¿Y usted entendió las preguntas que se le hicieron a Rosa Ruiz el día de hoy?
Sí.
Yes.
Okay. Are you in agreement with the settlement terms?
¿Usted está de acuerdo con los términos de este acuerdo?
Sí.
Yes.
And are you also in agreement with all of the questions that Ms. Rosa Ruiz was asked?
¿Y también está de acuerdo con todas las preguntas que se le hicieron a la señora Rosa Ruiz?
Sí.
Yes.
I'll pass the witness, Your Honor.
Cedo al testigo, señoría.
Mr. Calvert or Mr. Mulkey?
No questions, Your Honor.
No questions, Your Honor.
Mrs. Davis?
Miss Victoria Ruiz, are you asking the court to approve the settlement because you believe it's in the best interest of your children?
Señora Victoria Ruiz, usted le está pidiendo al juez que apruebe este acuerdo porque usted cree que es lo mejor para los niños, los menores?
Sí.
Yes.
No further questions, Your Honor. I pass the witness.
No tengo más preguntas, señoría. Cedo al testigo.
Any additional witnesses or questions for this matter?
No additional witnesses and no additional questions from the plaintiff.
Is there a recommendation that, first off, let me ask Mr. Ruiz and the second witness, do they have any questions?
Señora Ruiz y a ambos testigos, ¿tienen alguna pregunta?
No.
No.
Okay. Is there a recommendation of the guardian ad litem?
Yes, Your Honor. After meeting with Ms. Rosa Ruiz and reviewing the documents, I do believe that the settlement offers made to both minor children in this matter are adequate to compensate them, and I would ask the court to approve the settlement at this time because I do believe it's in their best interest.
Okay. Is there an agreement made as to the amount of the guardian ad litem fees?
Yes, Your Honor, I did confer with defense counsel on it. I believe there's two defense attorneys, but I guess Mr. Mulkey can confirm.
Yes, Your Honor. We confirm.
Okay. The court will go ahead and approve the settlement as requested by the guardian ad litem. Mr. Savitz, I think this may be your last prove up with me, isn't it?
I have one more if I can get Medicaid to reduce.
Okay, well, I was going to say thank you for all your service over the years.
Thank you. Thank you.
A wonderful judge coming up. So
Thank you.
for your service. And court will approve the settlement. You guys have a great rest of your day, and we will go ahead and let you go. Thank you so much. And I just signed the final judgment. It should be in the system by tomorrow.
Ahora el niño.
Thank you, Your Honor.
Thank you, Your Honor.
All right. Having a problem.
Señora, aprobaron, el juez aprobó su solicitud del acuerdo y que va a estar listo en el sistema el día de mañana.
Okay, let's go to our next hearing, which is I believe is Krapau versus Combs. Are both sides here on that?
Yes, Your Honor.
Yes, Your Honor.
I'm sorry, Judge, may the interpreter be excused or?
Okay, sorry about that. Yes, you may.
No, no problem. Thank you, Judge.
You have a great day as well, okay?
Thank you, you too, Judge.
All right, let's go to, did we already go on the record on Kapow, Tony?
We just need announcements.
Okay, let's go ahead and make announcements on Kapow versus Combs.
Your Honor, this is John Johnny for the defendants. Combs.
A mí no me han dicho que cuelgue. Pues ya se fueron.
Both sides make announcements. There was some crosstalk there.
Go ahead. Yes, Your Honor, this is John Galini representing the defendants, Combs, and the movements in this motion to modify judgment today.
And Your Honor, Maureen Farrell appearing on behalf of the plaintiffs.
All right, let's proceed.
Thank you, Your Honor. Your Honor, this is a motion to modify the final judgment that was rendered by this court on August the 22nd, 2022, after a jury trial that occurred in the latter part of June, beginning of July. Plaintiff's motion of the judgment was heard by this court on August the 22nd, and the defendants objected to the entry of that judgment, but as a final result of that hearing, this court granted the entry of plaintiff's proposed judgment as it had been presented to the court. That included $30,000 actual damages for past actual damages for Michael Combs, the defendant. However, it did not include any prejudgment interest for the defendant's damages that were awarded. Also, we asked that the judgment be modified to reflect the judgment amount for prejudgment interest in that being $1,241.10. Beyond that, we're asking that the judgment be modified to clarify that the constructive trust that was issued as part of that final judgment be issued in favor of the siblings as a whole instead of just the plaintiffs as was represented to them in the jury trial. And finally, last but not least, that the judgment be modified to no greater than the limits that were pled by them in their pleadings.
Response?
Your Honor, with respect to prejudgment interest, the award of prejudgment interest is equitable. The court is within the court's sound discretion. Prejudgment interest on the $30,000 awarded to Mr. Combs was not requested prior to the entry of the judgment. The court certainly does have jurisdiction to modify its judgment to allow for $1,241.10 of prejudgment interest. But in the court's final judgment, the court set off the amount awarded to Mr. Combs, $30,000 against the $1.562 million awarded to the plaintiffs, and awarded prejudgment interest on the balance of that. So the $30,000 that had been awarded to Mr. Combs was already incorporated and reduced the prejudgment interest that was awarded to my clients proportionately. As prejudgment interest is in the discretion of the court and an equitable remedy in order to encourage the parties to settle and in order to
Let me just say this, if I didn't award prejudgment interest, I always award, I don't know that it is equitable, but I always award prejudgment interest unless there's something very unusual. So I'm going to allow prejudgment interest.
In the amount of $1,241.10?
Whatever the appropriate amount is.
Okay. So then the second issue is that at the close after the jury's verdict was read, we asked the court to impose a constructive trust for certain assets that are belong to Mr. Combs. They're his business, Michael Combs Properties LLC, that were assets that would be available to satisfy the judgment. We read those assets into the record. The court imposed the constructive trust. Now, Mr. Galini, on behalf of his client, is asking the court to declare that trust is for the benefit of all four of the Combs siblings. In other words, he's asking for relief that is collateral and extraneous to the issues that were before the court. This was not a lawsuit. This was a lawsuit against Mr. Combs and his company for fraud and breach of fiduciary duty against my clients. It was not a probate matter about about Betty Combs, the mom's estate. The court doesn't have any jurisdiction to create legal or equitable interest for anybody outside of this litigation. If it would be better that the constructive trust was imposed solely to secure assets available to satisfy the ultimate judgment. It would be better to just dissolve whatever constructive trust than to create new legal or equitable interest in favor of outside parties to the litigation that is the subject of the judgment. Finally,
what is your request exactly? That I just deny the request?
Yes.
Okay, I'll deny the request.
Okay. And then the final issue, Mr. Glaney, was that the verdict was in excess. Am I correct that the verdict was in excess of the amount pled?
Correct.
Okay, so that is true, Your Honor. The court's verdict was the jury verdict was in excess of the amount in the pleadings. And so when I filed my response, I also asked the court for leave to amend the pleadings to conform with the verdict. Mr. Galini has before this court a motion for new trial in which he complains about the excessiveness of the jury verdict on many grounds, not just the amount in the pleadings, but also on legal and factual sufficiency, and also creates an attack on the breach of fiduciary duty order that the court had previously rendered.
What does the current case law say on the issue of if you get an excess of the amount pled, what's the remedy? I can't imagine this. You have to reduce the recovery. What's the remedy?
Your Honor, may I? And Mariah, I think you'll be fine with this as well. First of all, we asked for this because it certainly was a surprise and an amount above and beyond anything that we had ever heard of for actual damages that has gone on through all of the discoveries and through every aspect of it. So it certainly is clearly not only a small amount above what was pled, but nearly doubling the amount of what was pled, which you can imagine would certainly surprise the client at trial as it did us. But as far as your direct question, Your Honor, the answer to the question actually comes from an appeal that came from your court before the Dallas Appeals Court back in 2020. And what came of that, and the case law goes back to, I believe it's Green law, Greenhow. But basically, the duty of the court to go within the boundaries is a strict duty so long as there's no vacation or amendment or modification of the judgment. We have not heard the motion for leave, so that can't be before the court today. And you might put off for another day until that is to address this. But as it would stand right now, you would have the authority to move forward. However, like I said, that does not negate the fact, because in the same case, then upon their motion for leave being heard, and also if we can't show surprise, then the case law is that they would have an opportunity to, for that regard, so long as it wasn't new claims.
Ms. Farrell?
Yeah, so the Texas Supreme Court in its Greenhalgh versus Service Lloyd Insurance Company reviewed a post-verdict motion to amend the pleadings and said that the trial court has no discretion to refuse the amendment unless the opposing party presents evidence of surprise or prejudice or the amendment asserts a new cause of action, right? Then following up on Chapin and Chapin, that is also Texas Supreme Court 1992, the Supreme Court said that instances that are of formal procedural nature, including increasing the ad damnum, the amount of damages claimed, which simply conform the pleadings to the evidence at trial, should be permitted. And so I think that Mr. Delaney raises a valid point that the maximum amount demanded in the pleadings was $1 million. The jury awarded 1.562. But also it is still within the court's discretion. And in fact, I'm not even sure it's discretionary following Greenhalgh that the court should consider our leave to amend the pleadings to conform to the verdict And then the court has the opportunity, because it has Mr. Galini's motion for new trial, or in the alternative request for remediator before it on November the 4th, where the court can then decide whether we should be whether the damages should be reduced for any variety of reasons that Mr. Galini has brought before the court for the motion for new trial. What I think is not appropriate today is to refuse us the opportunity to hear the leave to amend to conform to the verdict and to reduce the judgment to $1 million before the motion for new trial is heard.
So procedurally, it sounds like the best way to do this is just wait on this issue, is what you're both saying, it sounds like.
Your Honor, I'm going a little bit of a step further, just saying basically the next aspect of the same Greenhoff case is because the judgment had not been vacated or modified, the trial court cannot grant a motion for leave. Obviously, they haven't had one set yet. However, in this court today, you do have the discretion, Your Honor, to reduce it down to. And obviously, motion to leave later, they can come back and fight that.
At this point, I'm just not ruling on that. I'm going to hear this all at the same time. Ms. Farrell, you need to get an motion to leave, and then let's hear this all at the same time. And then if you can argue the surprise issues, you can argue your issues, and then we figure it out at that point.
Your Honor, how would you like to address then the motion to modify then on the interest? Would you like it to say heard on October 24th?
Yes.
And have that
on October 24th. And just, I guess for the third issue, just say that the court has deferred ruling until a later date.
Would you like me to mirror the previous judgment, but for the addition of interest, and then add the third issue to be?
And share it with Ms. Farrell,
Yes,
and get that to me by Friday, no later than this Friday morning at 9 a.m.
Thank you, Your Honor.
And Your Honor, I had filed the motion for leave to amend the pleadings to conform with the verdict was in my response.
I agree with that, Your Honor.
Am I able to set that for hearing?
At the same time that he's going to have his heard.
For November the
That's
4th.
the end of my time, but we'll have to just talk fast, Your Honor.
Sounds great. You guys have a great day, okay?
Thank you, Your Honor.
Okay. Zubrick versus Gonzalez. It's 3 o'clock. Tony, you ready?
Yes, Judge.
Go on the record on DC 1918220. Zubrick versus Gonzalez. Council, make your appearances.
David Welch, Van Shaw, and Jeff Levenger on behalf of Chuck Zubrick. And Mr. Levenger is going to be taking the lead, Judge.
Okay.
Jason Friedman here on behalf of the defendants, Your Honor.
Keith Kramer on behalf of the Valley View Park Estates Homeowners Association, Your Honor.
Kelly Milligan on behalf of defendant Ronnie Henderson.
Okay. All right. Are we ready to get started? Let's go ahead and proceed.
Yeah.
Go ahead and proceed, guys, on the plea to the jurisdiction.
Yes, Your Honor. Is the court ready for me?
Yes, please proceed.
Your Honor, the court's very familiar with this case. It's been going on for quite some time. The individual defendants here have filed this plea of the jurisdiction. The primary issue before the court today is standing. Despite the fact that the plaintiff's position now is that they are trying to mix and confuse capacity and standing to further confuse the court. Simply put, the plaintiff has no authority to recover, bring suit on behalf of any individual homeowners and or suit in his individual capacity to enforce these declarations. Therefore, he lacks standing. And a plea to the jurisdiction, which can be raised at any time for trial, is the proper challenge to a party's lack of standing. And the standing today focuses on who's the correct party to bring suit. I have cited, and I'll point the court to Hawkins v. Walker, 233 Southwest 3rd 380, which is a case very much on point here, discussing the lack of standing. And the plaintiffs seeking recovery under the property code, which they are seeking recovery under 202.004. And the Court of Appeals is very clear about that. And it's stated that in construing section 202.04 to determine whether an individual had standing against other private landowners, they look at the legislative intent, and unless a statute is ambiguous, they discern that intent from the language of the statute itself. And in doing so, 202 expressly provides that a property owners association or other representative designated by an owner of real property may sue to enforce a restrictive covenant or to protect property covered by a restrictive covenant. This is the exclusive language that evidences a legislative intent that only property association property owner associations or the designated representatives of property owner may sue for civil damages. Individual property owners are not identified as statutes who can recover. And the issue here is that Mr. Dubarek says that he was an appointed representative, but he's not. He had to be appointed by the homeowner association. If the court takes the plaintiff's position that any individual homeowner can go round up one other homeowner or two other homeowners, then you're gonna have a free-for-all in the court system, because everyone's gonna go, well, hey guys, we get around the property code and the legislator's intent by saying, hey, you appoint me, and we could just go sue. That's not how this works. This would be a free-for-all on the judicial system. And there's no dispute about it. Mr. Zubarek has pled for damages under the property code, Texas Property Code 202.004C, and he's purporting to be an appointed representative, which he's not. And they want to misconstrue the bylaws and declarations to give him authority to sue, but it's not there. It's not there. And at the end of the day, you got to go with what the legislator's intent was and what the case law says, which is Mr. Zubarek does not have standing, and this case must be dismissed.
Give me that's that 202.002C. Is that what you said?
No, I said what he's relying on.
Yeah.
2.02.004C.
So I said 2.02.
Yeah, 202.004C.
202.004C. Okay.
Mm-hmm.
A response, Mr. Levinger?
Yes, Your Honor. Thank you. First of all, this is not a proper plea to the jurisdiction at all. That's because the defendants are not challenging Mr. Zubarek's standing. They don't dispute that he's been personally aggrieved. or that he has a justiciable interest in the subject matter of this case. And those are the tests for standing. And of course, he's been personally aggrieved. They built fences in this HOA in violation of the declaration. And he's an owner in the homeowners association, and he has to see these fences. So he's been personally aggrieved. What they're really challenging, Your Honor, is his legal authority to bring this suit. They said that in their motion. They're challenging his legal authority. But that is a matter of capacity, not standing. In fact, in the recent Supreme Court case of Pike versus EMC Management, the court said the question whether somebody actually has the legal authority to question whether somebody has capacity is a matter of whether they have legal authority. And it's significant that they're challenging capacity because they've actually waived it twice. They've waived it, first of all, because 7 out of 8 defendants never filed a verified plea denying capacity as required by Rule 93. The one who did, Henderson, made a different capacity argument than what we're hearing today. She said something like, Mr. Zabarak is not a beneficiary of the easements, but that's not even the argument today. More importantly, Your Honor, none of these defendants raised this argument before the court granted summary judgment in favor of Mr. Zabarak back in October of 2020, finding that their building of the leases violated the declaration. That would have been the time to raise this capacity argument back at the time the court was ruling on our motion for summary judgment, but the court granted it, and now it's too late to bring this capacity argument. So the plea should be denied for that reason by itself. Turning to the merits, though, if the court were to get there, as I say, this court has already concluded that the defendants violated the HOA's declaration by building fences in the utility easements in the HOA in violation of Article 11. Now, Zabarak had the legal authority to enforce the declaration under 2 things, really, Your Honor, not just the property code, and I'll cite you the right section in a moment, but also the declaration itself. He had the right to sue the defendants in order to enforce the prohibition against building those fences. First of all, I'll read to you from Article 12, Section 1 of the declarations, which they've attached to their plea to jurisdiction. It says, the covenants and restrictions of this amended and restated declaration shall run with and bind the land subject to this amended and restated declaration, and shall inure to the benefit of and be enforceable by the association and or owner of any land subject to this amended and restated declaration, their respective legal representatives, heirs, successors, and assigns. Mr. Zabarak is an owner, and he's entitled under Article 12, Section 1 to bring an enforcement action. And then you have Section 3 of Article 12, which says exactly how you do it. Enforcement of these covenants and restrictions may be by any proceeding at law or in equity against any person or persons violating or attempting to violate them. So that's what he's done. He was authorized under Section 1 to bring an enforcement action, and he brought it under Section 3. Separate and apart from the declarations, Judge, you have Section 202.004. It's actually Section B of the Property Code, 202.004B. And here's what it says. It's right on point. It says a property owners association or other representative designated by an owner of real property may initiate, defend, or intervene in litigation affecting the enforcement of a restricted covenant. So it says designated by an owner of real property. It doesn't say designated by the homeowners association. It says either a property owners association or other representative designated by an owner.
I assume Zabarak is an owner of real property within the association, correct?
Yes, not only is he an owner, but he was designated by 9 other owners to bring this enforcement action on their behalf. In fact, the statute only requires 1 owner to designate somebody. In this case, 9 people designated him. So he has authority under 202.004B. That's really it, Your Honor. He's got the legal authority based on either the declaration or the statute. And if the court even reaches the merits, the plea to the jurisdiction should be denied for that additional reason.
Anything else, Mr. Friedman?
Yeah, Your Honor, if I could point out a couple things. One, Mr. Zubarak does not have authority to file this lawsuit under the declarations. And what he left out is in section 9, where it addresses a homeowner's authority and remedy, it says that the homeowner can bring a disagreement with another owner to the board of directors. That's what it says. So if anything else is hocus pocus. And if this argument that Mr. Zubarak himself, who's an owner, could have just nominated himself and he could have gotten his neighbor to do it, then we're going to have a significant issue in the court system, because then every member of an HOA is going to be able to circumvent the legislative intent of 202 and file their own lawsuits. I may also add that the court may have entered a summary judgment, but they didn't enter a final judgment. And the last thing I checked, that was interlocutory. And this case is still active and you're still the judge. So I think the court can overturn it. And that's why we have trials.
So Mr. Levenger, do you feel this is hocus pocus?
I'm sorry, I didn't hear what you said.
I'm just kidding. So do you think this is hocus pocus?
No, I don't think it's hocus pocus. I think it's a legitimate suit.
I want to say this, good drafting by both sides. Thank you so much for bringing this to me. Court is going to deny the plea to the jurisdiction. Mr. Levenger, did you submit an order on that?
We e-filed one, I think, on Friday, Judge, but we'll send in another one if you can't find that one.
See if I can find it. Give me 1 second.
Judge, I can give you the firm date on that. Hold on.
I have it. Let me just, any objection to the form of the order?
I don't have their order in front of me, so I don't know.
It's pretty standard. All right, guys, it was good seeing you, and we will catch you on the next one, okay?
Thank you, Judge.
Thank you, Your Honor.
You have a great day.
Thank you.
Thanks.
Is there anyone here on any other cases? I think I'm done with my docket, but I see some of the names I know.
Yes, Your Honor. So I'm here for the state of North Dakota and Shandon Collins matter.
Oh,
And I'm here representing the defendant on that one, Shannon Collins.
okay.
And I was wondering if you can reset the hearing if the opposing counsel agrees. I caught a COVID over the weekend and I can't really speak anything right now.
I have no problem with that. Any opposition?
No, Your Honor.
Do you want to just contact the clerk's office to request a new date?
Yes, Your Honor. Yes, Your Honor.
Hope you feel better. And yeah, just we have a non-jury trial in this case for April 25th. So just make sure you get it set well before then.
Yes, Your Honor. Thank you.
Hope you feel
Thank
better.
you, Your Honor. May we be excused?
You may.
Have a good day.
You too.
Thank you.
Tony, tomorrow, I think we still have one case. Let me double check. I think we're down to one case. Yeah, we still have one case left at the moment. So
It's settled, Judge.
oh, the last one settled. Okay, then never mind, Tony. We will see you on, unless something changes, we'll see you Thursday at 10.
Okay. Okay.
That's going to be, enjoy your time because we're about to get real busy. So
All righty, I will. Y'all have a good one.